And now we are going to look at the use of force in international law. So you realize that the historical background in international law was that uh, by the years of 1914, the years of 1945, where we experienced World War, we realized that various organizations were formulated, uh, majorly the UN, that is the United Nations, and there was enactment of certain laws such as the UN Charter uh, around the years 1945. Now, when they enacted the UN Charter, there was an agreement that, you know what, let there be no wars again. Like they were trying to fight against the wars to avoid world war, which had affected or impacted many people by then. So when they came up with the UN Charter, uh, that charter prohibited the use of force, that there shouldn't be any other, or there shouldn't be any country or any person that should use force. Like it called for peaceful settlement of issues. So when you look at Article 2, as Clause 4 of the UN Charter, Article 2 in bracket 4, that is Clause 4 of the UN Charter, it prohibited the use of force in international matters, meaning that it called for peaceful settlement of issues. Now, the question is, what is force in international law? When you look at the provisions of Article 2.4 of the UN Charter, force can either be threats, mere threats of saying that Uganda is going to attack Rwanda. In international law, that amounts to force. A mere threat, even if you don't put it into action, it is enough to prove that there is force. Then the other can be use of arms, actual arms, that is armed forces attacks. You go and attack a certain country. So that is the other way force can be seen in international law. Then the other one can be indirect use of force. For example, you can be a country that will force you indirectly, but you don't show that you are participating, but you indirectly push another person or another country to go into actual warfare with another person. So you have to know the various forces that exist. One, mere threats, enough is force. Two, indirect use of force. Three, the issue of actual armed affairs. Now, when you have seen that international law prohibits the use of force in in international law, that is Article 2.4, we have to know, are there certain exceptions, or what was the rationale behind the prohibition of use of force? There is a principle that was developed over time that a person should interest himself with, and that is the principle of non-intervention. The principle of non-intervention prohibits or called for countries to be independent, regardless of whether for you have money or you don't have money, regardless of whether we are small, you are big. Non-intervention of a certain country into the affairs of another country. So if you are USA, I'm Uganda, don't intervene in my affairs. If I'm Uganda, you are USA, I should not intervene in your matters. Why? Because of the principle of non-intervention. Let Uganda do its own part. You do your own part. Why? Because you are trying to avoid that issue of use of force. We want to maintain peace. However, even if the law is clear that you should prohibit or desist from using force, are there any exceptions to the principle? That could be the general rule in Article 2.4. But are there any exceptions to when force can be used? Yes, the same UN Charter has given various exceptions to when force can be used, and one of the provisions can be in self-defense. When you look at self-defense, Article 51 of the UN Charter gives a country power to use force while it is defending itself. For example, if country A attacks country B, meaning that country B has used force, so country B that has been attacked by virtue of Article 51 is given that power to defend itself using force. However, while country B is defending itself, there are certain limitations. The force should be proportional to that one that has been used by the attacking country. For example, If country A uses guns, why would you bring out nuclear weapons? Then the force you are using is not proportional. So even if you have a right to self-defend yourself in Article 51, it should be that force that is proportional in defense. Then the other one is, the other exception of use of force is collective use of force by UN agencies. So you realize that when you look at some of the organs of the United Nations, there is what we call the Security Council. So the Security Council comes up, or it deals with matters of security internationally. So they gather various forces, because it doesn't have forces. So it can gather various forces, or forces from the various countries in order to fight someone. So where the country has been told by UN to desist from something, and they keep on doing the same, by virtue of Article 24 and 25, Article 24 and 25 of the UN Charter, it gives the UN Security Council to join forces to come and fight that person that is desisting, that country that is desisting in committing international offenses, among other things. Then the other exception to when force can be used in international matters is where a state of UN is using force against a former state. Use of force against a former, actually, use of force against a former enemy of UN. Use of force against a former enemy of UN. Now, when you look at provisions of Article 107 of the UN Charter, who is a former enemy of UN and who is a member of UN? So you realize that a member of UN is this person that signed on the UN Charter, you ratified. But you remember that these people joined forces, but they are countries that they were fighting against. For example, if I can remember very well, Japan, among others, all those were against UN. So if you are among those people that were fighting the UN nations that had developed by then, my dear, you are still branded as a former enemy. So where a state or a member of the UN that ratified to the UN Charter uses force against that former state or that former enemy, where that former enemy is trying to like gather in order to attack the UN state, then it is given power to use force under Article 107 of the UN Charter to defend itself or to fight that former enemy of UN. Then the other one is humanitarian intervention. Humanitarian intervention can also be one of the exceptions to Article 24, where force can be used. With humanitarian intervention, this is where country A has gross human rights violence. For example, you are in Uganda and you know there is a lot of human rights abuse, or any other country. So country B can attack Uganda, use force in order to see that there is no human right intervention or violation. A case in point can be the raid at Entebbe during the era of Idi Amin Dada, where Israel had to come in to attack Idi Amin Dada because there was human right intervention, where they had to put under custody the citizens of Israel. Or even we can see human right intervention where NATO has interfered in Libya. We have seen interference in Rwanda, all those in order to protect the rights of certain people or the citizens in another country. Then lastly, it is a protection of nationals. So the other exception to when use can be used is where you want to protect nationals. For example, a case in point is one of the raid in Entebbe. For example, if a Ugandan citizen is in Kenya and they have been arrested without valid reasons, among others, Uganda can use force in order to come and protect its nationals abroad. As you saw Israel do it in Uganda during the era of Idi Amin Dada, that is the raid at Entebbe. They were trying to protect the nationals. So those are some of the exceptions to when we have to use force in international law. However, you should always desist, or international matters should always, or international countries or states should desist from using force because of the principle of non-intervention. Thank you very much.